James Freeman said a lot of stupid things in this video. The biggest, stupidest thing he said was that he wanted people to call Bill Wayburn, the sheriff in Tarrant County. Completely unmindful of the things he's being charged with and the fact that he has a hearing based on whether or not the judge in Arizona is going to think that the threats and comment or threats, internet threats, something like that, that he's charged with the felony for Leon Valley has merit. We already know that Mr. Freeman has a conviction in Arizona for making internet threats. We know he's currently charged with, or internet harassment, excuse me. We know he's charged with internet harassment in Dallas County, currently going to trial over it. And here our boy is again, thinking he's smart, trying to well don't call Flood'em, and don't call now because you won't get a hold of him, but I just want everybody to call this phone number to seek redress from the government. He's an elected official. Anyway, so that's not really what I wanted to do this video on. What I want to do on the video, this is a link. This is the link that James Freeman provided. Multiple stories relating to lawsuits in court rulings on police and cities deleting Facebook comments. This is literally, just in case you don't believe me, this is literally this. There we go. And most of these are just, the ACLU suing. Can police delete Facebook posts? Experts say no. Experts say no. Maine governor sued for deleting Facebook comments. He's sued. That doesn't mean he lost. It means he sued. ACLU sues Maine's governor. Again, doesn't mean he lost. City sued. This is one that James talked about. City sued after police delete Facebook posts. This was it was the Hawaii one. This is the one that he fixated on. Hawaii Police Department ordered to pay $31,000. He's like, well, that doesn't seem like a lot for 2 years. It's not a lot, James. They didn't get everything they wanted. Anyway, if you actually click the link and read it, James, they settled all the issues except for the plaintiff's attorney's fees. And the plaintiffs wanted $65,000, and the plaintiffs ended up getting $31,000. You may notice that that's less than half. You don't always get attorney's fees. You don't always get all the attorney's fees you want. In fact, normally you can, in my experience, from what I've seen, you've got to have like a rock solid case, and the other side has to be just plumb stupid for trying to defend it in order to get attorney's fees. And I mean, it's just not, you just can't bank on it. So we have lots of things about, they're being sued. Agencies sued. They've been sued. Did they win? What can your link tell us? Oh boy. Oh, this is going to be fun. Oh, this is the HPD. All right. So your Google search, James, is pretty retarded. The HPD thing was a nothing burger. The court never determined whether or not the HPD actually violated the First Amendment rights of these people whose comments were deleted, or this person whose comment, whatever. This is another one of the links that I opened up. They were just sued. I mean, it doesn't even, anyway. And then he brought up Trump. Trump did lose. Trump was deleting or blocking people from being able to view and post on his personal Twitter account. Not his president Twitter account, but his personal Twitter account, an account that he had prior. James didn't even know. Oh my God, it's just terrible. It's terrifying. It's terrifying that people listen to him as a source of information. He doesn't understand the difference between a segregation unit and solitary confinement. He doesn't understand the difference between having your vehicle impounded and your vehicle stolen. He's not stupid. It's willful ignorance. That's all I could think, is it's willful ignorance. But yes, Trump did lose in the district court. But we all know that your personal account, you could block, mute, hide, whatever, people from it, because Trump is not the government. Trump in his role as president is the government. So like Trump's presidential Twitter would have more restrictions on it. There would be a First Amendment analysis you'd have to go through. But Trump, in his personal capacity, isn't the government. Trump can tell his kids to shut up. You know what I mean? It's Trump in his personal capacity isn't the government. Trump as president is representing the government. So yes, the Justice Department is appealing the ruling, and just like in the case where the Ninth Circuit said that, you know, Trump was violating the Constitution by restricting the visas of people from 8 different countries, or however many different countries. The Ninth Circuit held that that was unconstitutional, and then it goes to the Supreme Court, and it's a plenary power. If you're not blinded by bias, and you could just step back and look at it, you know, and yes, the Supreme Court is going to just step back and look at it, and you could expect all the Democratic ones like Sotomayor to go one way, and you could expect Clarence Thomas to go the other way, and you could expect the group in the middle to look at it rationally and be like, well, if we prevent Trump from moderating his own private social media accounts, then the next president, if the next president is whatever their particular political persuasion is going to have the same issues. All of a sudden, Obama isn't going to be allowed to moderate his private Twitter. All of a sudden, Kamala Harris or whoever, Trey Gowdy, whoever the public figure is, will not be allowed to have a private Twitter account, their own personal Twitter account. So I'm very sure that the Supreme Court's going to strike that down. Now, to the meat of the matter, James just asserts flatly, without knowing the facts of the law, that the city can't delete comments on Facebook and it can't block users on Facebook. Now, where is James? Why do we know James is wrong? And I'm actually asking you this. I'm going to give you a second. You don't even have to pause it. I'm just going to give you a second to think, why do we know James is wrong? And we've gone over and over it again, and I've been razzed over it, but this is the actual answer. It's because you have to do a forum analysis. That city's Facebook page is a forum. And all you have to do is figure out what kind of forum it is. If it's the government as a speaker, then if they have set it up as the government speaking, then they could prevent everybody else from commenting without an issue. Now you're going to say, well, they're not preventing everyone else from commenting. We don't know that. I don't know that. I guess I could check, but we're doing a more theoretical exercise at this point with that one caveat. So roll with me on that one. Now you're going to say, well, they are allowing people to comment. Well, then the next step you have to do is say, well, what if they can convince the court that it is a non-public forum? The government can control on a non-public forum, like everything inside from the sidewalks of the Supreme Court grounds, everything from the sidewalks in a post office grounds, everything from the sidewalks in a jail or jailhouse grounds. And what kind of analysis would you have to use there? Well, it has to be content neutral and viewpoint neutral. And it has to be reasonable. The regulation has to be reasonable. Now, that's probably not where a court's going to go. I mean, that's like best case scenario for the city. That's probably not where the court's going to go. Oh, by the way, and the reasonable rule has to be non-arbitrary. It can't be arbitrary. It can't be arbitrary because that would be vague, constitutionally vague. All right. So what it's probably going to be, it's not going to be a traditional public forum, but it's probably going to be a limited, it's probably going to be a designated, there we go. It's probably going to be a designated public forum. And in a designated public forum, it's basically as long as it's open to the public to comment, then you have to do it has to be, any regulations or any policies have to serve a significant government interest, right? They've got to be content neutral, obviously. And they have to be narrowly tailored to achieve that significant government interest. So what we have to know is what the policies are that are controlling this particular web page, don't we? We have to kind of guess which way the government or which way the court is going to go in determining what kind of forum it is. And then we're going to have to know what the policies are. Now, I don't think James knows the policies. I would hazard a guess that James doesn't know anything because James rolls in with a 2-second Twitter or 2-second Google search, and he proudly proclaims that the city's practice of deleting comments is unlawful. What if the comments that were deleted were child porn? He didn't even know what the comments were until he did a FOIA request. Before he even did the FOIA request, before he knew what the comments were deleted, I still doubt seriously that he knows what the policy is, what the city's policy is. But so before he knows the law or the facts, he's already declaring it unlawful. And that's what I'm trying to help people understand is why it's not necessarily unlawful. Because if their policy serves a significant government purpose, like maybe they have it no swearing, no swear words. And what kind of significant government purpose would that be? Well, uh, let's say that kids may end up looking at that Facebook page. Maybe they have content on their Facebook page like talking about, fairs. Like, ooh, summer fair, bring your kids. And then you have some asshat in the comments swearing like a sailor. Well, if they have a policy against the use of swear words on their forum, well, does it serve a significant government purpose? Yes, it protects children who may be using that forum from that kind of language. Is it the least restrictive way to do it? Probably. I mean, I can't think of a less restrictive way to prevent kids from seeing that kind of stuff. And is it content neutral? Sure, they don't care. They don't care what you're talking about. They just don't want you to use swear words while you're doing it. Bada boom, bada bing. Easy peasy lemon squeezy. And then maybe they have a policy if, 3 times you get 3 chances, they'll delete your comment and send you a notice saying that, hey, we deleted your comment and we would appreciate it if you don't use swear words, because there's kids who come here and look at this stuff. And maybe they send you a second notice and then a third notice, and if there's a 4th time, maybe their policy is to block that person from being able to post. Maybe they have fewer chances. I don't know. I don't really care. But my point is, they may have a significant government purpose, and the solution may be narrowly tailored to achieve that significant government purpose, and it may be content neutral. So all I'm saying is that you got to kind of understand a little bit before you walk in there and say it's unlawful. You got to know the facts and you got to know the law before you can make a claim like that. Anyway, I've rambled long enough. Thank you very much for watching, and have a great day.